Very happy Wednesday, January 29th to you, and welcome to another edition of the Elville webinar series. And our topic for today is one we offer on a quarterly basis, which is understanding estate and trust administration. Your presenters are very own managing principal and lead attorney Stephen Elville, and I'm Jeff Stauffer, community relations director with the firm, and I'll be your moderator today. And a few housekeeping items. We have some new people here with us today. We encourage your general questions, so note them in the questions panel at any time, and we'll pause periodically to address them. If you have a specific question about a need directly for yourself or a family member, it may be best suited to talk offline with Steve in a meeting. And also, you received the presentation slides and two important checklists that Steve is going to be referencing. You received that by email yesterday. If you didn't receive it for whatever reason, it's also available in the section marked handouts to download at this time. And we have some professionals here today. Welcome as always. You can receive 1.5 continuing education hours for attending. So if I don't have your ID number or an accreditation, please send that over to me so I can submit hours and get certificates out as soon as possible. And you'll also receive a post-webinar feedback email right after the presentation. So please take just a couple minutes to fill out this brief survey, but it's very important, and offer us your thoughts about how things went today. And speaking of questions, a question for you. Have you achieved your planning goals, or have those goals perhaps shifted since you had your planning reviewed? And here at the firm, Steve and our team here, we want to be a resource to your family and you for your planning needs. If it's getting started, reviewing documents, in a state administration matter perhaps, or something else, we're always here to advise and counsel you and offer solutions to your situation. So I want to offer Steve and the firm just a brief introduction, and we're going to jump right in. Lots of great information to share today. So you can see my screen here, Elville & Associates. We were founded in 2010 by Stephen Elville. We've been here in Columbia for that entire time and have expanded out to Annapolis and our new Rockville office. We have many different practice areas that we focus on a daily basis, and that includes estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection, which fall within estate planning and elder law. We have 9 attorneys, 12 staff members, and 3 locations, as I mentioned. And our mission, it's always been the same: to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we focus on education a lot here at the firm. Very important. We do it in many different ways, though, through our planning processes with our clients. We have different programs to suit all individuals and families, whether you feel you have very basic needs or very extraordinary needs. We're here to help you. And also educational webinars and workshops in the communities that we serve each year. And also by way of our accredited client care program, which makes us quite unique. One of only 2 firms in Maryland to have a client care program accredited by the Client Care Academy in Boston. Now being the beginning of the year, it's a great time to get started with the client care program. You can talk to me further about that. Just a bit about Steve. His work as an attorney for many years has been centered in elder law, special needs planning, and estate planning, with a bit of an emphasis in the areas of tax planning and asset protection. Steve is well versed in so many areas of law. As a member of the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, among many, many others, Steve works to bring peace of mind to clients by offering solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. Steve's a very seasoned speaker and presenter, if you haven't heard him talk before, offering many webinars, workshops for businesses, their employees, conferences, and continuing education events each year. And I'm very proud to partner with him on many of those. And in 2025, Steve was named to the Maryland Super Lawyers list for a 10th time and a 9th consecutive year. He also had a feature story written about him in the Super Lawyers magazine nationally about the Elville Center for the Creative Arts, which is our firm's charitable organization that he founded in 2014. I've been very fortunate to be the director of. Actually, I just have this right here, right off the slide. I'm going to show you. I don't know if you can see this, just got this from a school, Harriet Tubman Elementary School in Gaithersburg, with all the students putting their names on there, thanking us for a great donation that we provided to the school the other day. And just makes your day to get something like that. So we make a big difference. Feel free to talk to me further if you want to learn more about the Elville Center and how we make a musical difference in the lives of children each day. So having said all that, Steve, I'm going to turn it over to you. It's good to see you.
Good
Saw
to
you
see you,
breakfast
Jeff.
this morning, and here
Yes,
we are.
thank you. And are you going to laminate that poster, Jeff?
That's a good question, Steve. I think I'm actually going to try to find a frame for it,
All
and
right.
perhaps put it somewhere prominent in our charity area here at the Columbia office. We'll see, but going to do
Well,
something special with it.
Thank you for sharing that, Jeff.
Yeah. So I made you the presenter there, Steve. You should see that.
That sounds good. That sounds good, Jeff. I'm going to get my screen going here, and I just have to get my presentation off of my desktop. There it is. And can you see that, Jeff? Can you see my?
Yep.
Okay,
yep.
very good. Well, good morning, everyone.
Steve, if you hit the slideshow there you go.
Yes, thank you so much. Good morning, everyone, and happy Wednesday morning wherever you are. It looks like we have some moderating weather here in Maryland, so I'm sitting out here looking at the sunshine, so we're very fortunate about that today, and the snow is going away slowly, it looks like. And I want to thank you for your time. It's very valuable. We're beginning on time. We're going to end on time today. It's my extreme privilege to be with you, to be able to lead a discussion like this, which I think our primary purpose here is to dispel myths about trust administration and estate administration. So we want to dispel the fears or myths that you might have or might have picked up over the years, but we also just want to talk about the fundamentals of it. It's a very, very broad topic. I just came back from the Heckerling conference, attending it, in Orlando, and there's all kinds of advanced estate planning going on in this country today. But as we get down to the fundamentals, I want you to be able to walk away today with something very substantive that you can use and hold in your heart or hold in your hands to lessen anxiety, to make things easier. Heaven knows that we still have way too many complexities in the law, and hopefully this webinar will give you some tools that you can use to make things easier. We also know, before we get into any of the discussion of this topic, that many of you on this webinar today might have lost a loved one recently, or you might be in the process of losing a loved one. And if you are, our condolences or sympathies go out to you. We know that this is easy for us to talk about in a legal sense, but in the real world, this is a very tough topic. And so today, let's go into this topic knowing that we want to make things easier for you. We want to provide some substantive information. Thank you to all our professional and collaborative advisory team members out there, or friends of our firm, financial advisors, CPAs, life insurance professionals, life care managers, and anyone who has collaborated with us in the past. And to all of you who are clients or potential clients of Elville and Associates, we welcome you, and I hope you're having a good week. So what we're getting ready to talk about is not legal advice. As Jeff mentioned, we can meet one-on-one, and there would be an attorney-client privilege that attached to any such meeting, but these kinds of webinars are broad, and they are not to be construed as legal advice. This is purely educational. Now, before we get into the bullet points of what we're going to discuss today, Jeff had mentioned that you have some handouts that he has sent. I just want you to see a couple of these. These are checklists. These are critical date checklists, and I want you to be guided by these checklists. So many of us would be more efficient, or and many of you maybe do use checklists already. But if you get appointed into a position of authority as a fiduciary, in a fiduciary capacity to administer an estate or trust, or if you have nominated, obviously in your own estate plan, you've nominated your fiduciaries, your trusted individuals who are going to administer, or in some cases, a corporate fiduciary. But those individuals who you've nominated, or yourself as a fiduciary, you want to be guided by checklists. And it's very important not to fall in love with a particular checklist, because the laws do change. And as you've witnessed just in recent days, the new administration is changing things right and left. And prior to the new administration, there were some rapid changes in the laws as well. So we want to be guided by a checklist, critical dates checklist. We're going to go over those for your education today, but don't be too wed to a particular checklist, because we need to stay flexible due to potential changes over time. So we're going to talk about what estate administration is and what trust administration is. We're going to unravel some of those mysteries that happen after the death of a loved one. And we're going to kind of touch on things that have to do with taking care of survivors. And on the flip side, taking care of things in advance. So some of this will be educational for what to do now, but for some of you, it'll be educational about what to do now in your own planning, or for advisors to be thinking about their clients and what they should be doing for their own planning. And then we're going to talk about a legal step-by-step process. We're going to continue now to move the slides forward. We're going to talk about practical steps. We're going to talk about significant and potentially problematic legal and tax issues. And again, this is just the very surface of this, right? The things that advisors and clients should be aware of following the death of someone. And of course, there's the possibility that when someone passes away, they are married, with a whole set of issues about married couples and all the facts and circumstances, versus someone who is single. So we're going to go over some examples there. And we're going to talk about how personal representatives, this is the term of art for an executor. Someone in Maryland who is administering the estate is a personal representative. Some states call those executors. Whether it's a personal representative, trustee, or financial advisor, or a CPA, how can they all best work together in this kind of situation where someone has passed? Okay, so unraveling this mystery really starts with thinking about, why is this a mystery, and why is this one of the client, if you're a client or a potential client, or an individual just here today to learn, why is this one of the greatest concerns across the country when we talk about estate planning? Well, the reason it's a great concern is because, first of all, a lot of people are concerned about cost. What is the cost of administration? A lot of people want to minimize that cost, and that's really a discussion about a will versus a trust plan. But the other thing that is really driving this concern is just that most people are not educated about this. They don't know what they would do to kind of take over, get authority, and take over the administration of someone's estate or trust. They don't know where the resources are, and it's a feeling that's uncomfortable. So we want to address this issue, give you confidence that you can address these issues and that you can get help. You can hire professionals to help you. But the other thing is just it's surrounded in mystery. So for example, as we're going to see here, when someone passes away and they have a surviving spouse, this is one of the greatest concerns. What happens when there is a surviving spouse? What happens when someone has a trust and that trust now has to be administered? So we're going to talk about these concerns and try to dispel them. And I would say this is really the greatest mystery. This is really the greatest question, if you ask me, in estate planning, is what happens upon my death for the administration of my estate. But even the bigger question is, if you have a trust, what happens upon my death with my trust? How does my trust get administered? So we're going to talk about a will, which is subject to probate. Maryland is still a traditional probate estate, as opposed to Virginia, which I understand has very minimal probate compared to Maryland. So Maryland, Delaware, New York, these are traditional probate states where we have a process. We're going to talk about that. Trust administration. What if a person has a substitute for a will, which is a revocable trust? Or what if there's an irrevocable trust that has to be administered because the beneficiary, or the grantor of that trust died? The biggest mystery is really about the transitionary period. Someone has passed away. Now there is a period of administration and then the distribution of the trust. So this transitionary period, we're going to go over that. Who will be there for a surviving spouse? We briefly talked about this. So we're going to kind of talk about that back end issue. How will a surviving spouse or children have enough money? How long will it take for them to take over the funds of a person who died? The process, again, even though these circumstances are going to exist, as we will see in the examples today, every trust administration, every estate administration has a different set of circumstances. Some of them are similar, sometimes very dissimilar. But the thing that you must be driven by, or the advisory team or the fiduciary. They should be driven by a process. So as we talk today, if we are fortunate enough to not have lost loved ones yet, and we are just really trying to educate ourselves, we can prepare. We can prepare through planning, education, and as one very nice financial advisor once told me, organization. So we don't want to be so educated that we've got it all figured out and we have our planning in order, but not really totally organized. And that's why we want to be driven by a process and driven by organization. Now, we're going to spend just a few minutes on case examples, but before I do that, let's take about a minute. And some of you who have attended my webinars before, and Jeff and I have worked together for many years, sometimes we just take a minute to get grounded. What am I here for? What am I here to learn? What is it exactly that I'm listening to here? How could I apply it? Or maybe my purpose. What am I here for? What is it that I want to make sure that I get out of this webinar? And if Steve doesn't cover it, I'm going to ask a question so I get what I need out of this workshop. Let's take 1 minute. I'm going to start my timer now. Take a minute with your pad of paper, your scratch pad, your iPad, your tablet, your computer, whatever it is. Make some preparation here to write down substantive things that you might find interesting. But in this particular exercise, think about why you're here. What do you need out of this webinar? So we have about 10 seconds, 15 seconds. Actually, we have about 15 now. Remember, there are no wrong answers. You can write freehand. And there are no silly questions. Remember that. All right, so we're going to stop. I'm stopping the timer. I'm going to give you some case examples now, and we're going to take just a few minutes on each one. You know, sometimes when you're a fiduciary, you are going to be looking at a plan that is very clear. The person was very organized. Things are in order. They have a financial advisory team. They have a CPA. They have it all together. And I saw one of those cases just recently in the past week. And it's really a joy to behold that. Sometimes you're going to find a situation where there's a lot of retirement type assets. And many people today, as you know, have the majority of their assets in retirement type assets. This causes a certain amount of complexity, believe it or not, depending on what the planning is. Or there's a ton of non-probate assets. Somebody may have the opposite. They may have saved and done extremely well in life and have a lot of non-probate assets and no retirement assets, or a mixture. So we're going to see those kinds of cases. Then there are situations where there are certain needs. Maybe the planning was too simplistic, or it wasn't comprehensive enough. The survivor's situation is either not provided for well enough, or maybe the planning lacked complexity and documents were old, there's no flexibility. So maybe the situation is different than was anticipated. And then there are plans where there's just no planning at all. I shouldn't have said a plan, but just situations where there's no planning whatsoever. And the fiduciary is really kind of in a difficult spot, and they have to make judgment calls and rely on a lot of professional advice. So let's go to some examples, and I'm just going to make this program very interactive today. I want you to take about a minute on this example. And the first example here is a single person. I want you to just take a look at this, and I'll set the timer for a minute. I want you to silently, or writing it down, look at this and say, what would pop out at you about this? Someone passed away here. We see they have a will. And as you look through this, I want you to just say to yourself, okay, what is it that you see here that could be problematic? Let's just take about a minute on this. Take your time. There's no wrong answers. Let's see, even though this looks like a pretty straightforward situation for this single gentleman who passed away at age 77, what pops out at you, if anything? And then I'll give you my take on this. And through this process, hopefully we are going to walk away with something here that's substantive. So about 15 more seconds. All right, so in the interest of time, I'm just going to stop the timer. Here we have a situation where this elderly gentleman passed away. He had a will, he had only one child, so far everything looks pretty straightforward. Now, if he died in Maryland, what do we know? Well, the will is going to have to go through probate. So now the question is, what is probate? Well, the probate process, or probate, is the process of proving a will to be valid. So Maryland has a pretty extensive process. In some cases, it can be expedited, but if it's a regular estate, it will go through a process of about 9 months, and the will have to be proven valid. Creditors have to be given notice. And if you look at your critical dates checklist, you'll start to see some of the things I'm talking about. This checklist will talk about how the son here, Charles, will have to go get appointed as the personal representative. But now, what is in probate? Well, the residence, which was in the person's own name, is in probate. Why is it in probate? Because it was in his sole name. It has no joint owner and no beneficiary, so to speak. So the same thing is true in our example for checking, savings, and CDs, 200,000. No joint owner, no beneficiary. That's going to go through probate because it has to go through the process of being distributed. Everybody gets notice. In this case, it's very straightforward because of one child. What do we have as far as the IRA? Well, the IRA, Charles, let's assume that he was named as the beneficiary. He has to make a death claim on that IRA. He has a certain time period to be able to do that and move it into his own name as what? An inherited IRA. And then if Charles is well, he's healthy and well, we know that he is only going to have 10 years under the Secure Act to take this asset. So unfortunately, he will have to pay all the tax in 10 years. It looks like it was left outright to him. So we'll just assume he was the primary beneficiary. Now note that there's a savings bonds situation here. Will the savings bonds go through probate? And the answer is yes, because in our example here, the savings bonds were not jointly owned with Charles, and they are going to have to go through probate, and taxes are due. So this is going to be a question of how best to minimize the taxes and who will pay them. Will Charles pay them? Will it be on Felix's final tax return, or will it be on his estate fiduciary tax return, which is called a 1041? So just answering my own question that I asked you, the things to really take note of here are the IRA and the Secure Act because of the 10-year rule. Now, if Charles was a disabled child, he would not have to take that $400,000 IRA over 10 years. He would be exempt under the Secure Act, or if he had chronic illness. So there are some exceptions here, but we will just assume that Charles was well and healthy. So Felix made no lifetime gifts and he had no creditors. So other than the IRAs and the savings bonds and dealing with the probate process, as you'll see here in the checklist, this is a pretty straightforward situation. But there are a couple of nuances there caused by those savings bonds. Now let's go to the next fact pattern. I'm going to set my timer for 1 minute. And I just want you to get familiar with this, make any notes that you want to make. This is a little bit like Jeopardy, I guess, but we're just really trying to find out what are the nuances here that I would like you to be aware of. And I hope these 4 examples really just give you a set of reference points for how to think about this. This is almost like what happens when we were in college or in law school, for example, for some of you who may have gone to graduate school or whatever. We are asked to spot issues, right? So I think if you want to educate yourself, get familiar with these checklists, and we're going to go over other things, of course, other than these examples. This is all about issue spotting and just understanding where you need professional help or outside help. Okay, so our 1 minute is over. Let's look at this. This is a married couple. One spouse has passed away. Now remember, the mystery, right, that a lot of people feel in the United States is, if I have a trust, what happens to my trust? Well, here, the husband died first, and if we look down at the bottom of the slide, we see that this couple had a revocable trust plan. They had a substitute for a will. They had a revocable trust plan. And let's just make the big assumption that they funded their trust. Remember, a revocable trust will not work right unless it is properly aligned with the assets. Let's just go down this real quick. Let's assume the residence was in the trust like it should have been. The cash was in the trust. Remember, 401ks and IRAs do not go in a trust. Let's assume the joint brokerage account was in the trust. Let's assume that life insurance was properly beneficiary designated. Let's assume that they're Delaware residents. In this case, they loved Delaware. Like many of you do, they have a house down on the lower, slower shore. And let's assume that that was in the trust, because that was not a rental property as we see. This was just a residence for them, a second residence. So it avoids probate if it was in the trust. Now, you'll see that everything was outright to Janet. So upon the husband's death, Jack, his trust has to be administered briefly, or his portion of a joint trust, if it was a joint trust, it becomes irrevocable and it has to be administered. Okay, so this is the mystery that we're trying to unpack here. We're trying to unpack this, that there's no real big mystery here. It's just that his revocable trust, or his portion of a joint revocable trust, whatever they had, becomes irrevocable, and now it has to be administered and distributed to Janet outright. All right. Now, that should demystify a little bit the fact that when one person dies with a trust, it's very similar to estate administration. The estate has to be administered and then distributed. But here it was a trust. There's no probate. So it's just going to pass to the survivor after the brief administration. Now, what would happen in a brief administration like this? Well, Janet would want to make sure that everything is retitled properly in her trust and so forth, and then I'm going to get to the nuances. Janet is going to make tax elections. What tax elections might she make? Well, she might make the portability election. She might make the election that she wants to port Jack, in this case, this gentleman's name, port his exemption amount, which is now, right now, $13,990,000 per person. So she may say, I'm going to make the portability election and move his 13 million or almost 14 million in exemption over to myself, and also the Maryland exemption of 5 million, which also can be ported. So this is one of those things, but she does not have to do this quickly, except in the case of Maryland estate tax. Sometimes that's going to have to be done within 9 months, but at other times it can be done at 5 years with the portability election. So Jack has died. What are the nuances here? Well, Janet, the surviving spouse, is going to have to make death claims on his 401k and his IRAs if in Jack's name. What is Janet going to do 99% or 90% of the time? She's going to roll over those IRAs to herself, to her own IRA. So she's going to do that as a post-death action. She's going to make death claims on the life insurance. She's also going to just make sure that everything is funded in the revocable trust. So we can see from this example that when there is a couple and the estate plan is fairly straightforward, there's not a lot to do. So a lot of the administration that takes place on a broader scale is either going to be for a single person or for the surviving spouse when they die. So take it away here that this is straightforward. Now, the last thing I'll point out, this little thing down at the bottom again of the slide, it says, what if there is a formula clause? So for those of you who are not familiar with this, on the death of one spouse, there can be a formulaic provision about how the assets are divided up between the spouses. Many older trusts have this formula clause. So let's pretend that Jack and Janet, in this case, let's pretend they did their planning many years ago, never updated it, never changed it, and now one of them has passed away here. So that formula provision could drive a situation where not everything does go to Janet outright, and instead it's going to be broken up into various sub-trusts that we might call marital trusts or non-marital trusts. And that's beyond today's discussion, but just know that that would be the only complexity here, is if this trust that Jack had when he died, if it had a formula clause, then we would have a situation that wasn't so straightforward, and there would have to be some more administration to fund the marital or non-marital trust. Why would someone leave a marital or non-marital trust? Well, if it was in an old plan many years ago, in this particular case, it was probably driven by tax considerations. But now with portability, the ability for the surviving spouse to use the exemption amount of their deceased spouse in addition to their own exemption, we don't see so much of this unless a couple is extremely wealthy and have more than 2 exemption amounts. So couples that have more than 14 million times 2, or for Maryland purposes, more than 10 million, we will see formula provisions sometimes used. But otherwise, a lot of people plan just by what we call the portability method. So we're going to move on in the interest of time. Let's go to the next slide here. I'm going to now set my timer again. And here, what we want to do is just appreciate what has happened here. And this is the situation that I mentioned just a minute ago. We have a survivor now who has died. This is where the bigger, broader administration usually is going to be, unless with a couple, the person who died first had a lot of assets in their own name. So it is still possible to have a substantial administration on the death of only one spouse, but here we have a survivor, and now all of her assets are going to have to be administered. Let's look for nuances here that you might come up with, just for a few seconds. Anything that pops out at you. Now remember, here we're talking about a trust, so I want you to refer to your trust administration checklist, which in some cases you'll see is similar, surprisingly. All right, now having gone through about a minute, my timer just went off. After having gone through a minute of that, let's go through this. So now we see that 20 years later, this surviving spouse died. Now, let's pretend that her trust was fully funded as well. Her deposit at the retirement community, the continuing care CCRC, let's assume that came back to the trust. So that was good planning if that $350,000 came back to the trust. If it did not come back to the trust, where is that going to go sometimes? That's going to go into probate sometimes. So we have a probate estate here, which we wouldn't want. So that would have been a mistake for this person not to designate their CCRC deposit back to their trust. But let's assume in this case it was. Now we have cash in the trust. We'll come back to the IRAs in just a minute. We have the brokerage account in the trust. We have the Florida residence. She moved to Florida. She got tired of Delaware. She moved to Florida. So right now we have got what? We've got the CCRC deposit. That's a red flag. We have to make sure that's being taken care of because it may not come back until what? 6 or 9 months later when that CCRC room is finally rented and the facility, depending on what it is, gives back the deposit. We have a situation here where the children are going to have to make death claims on the IRA, so they only have a certain period of time to do that. And there's 3 children. We have to make those death claims and help them make them. And when they make those death claims, they're going to get individual what? They get inherited IRAs, inherited IRAs. The Florida residence is part of the trust, so it just has to be administered. Are the children or the trustee who's a successor, are they going to keep that Florida residence? Are they going to sell it? And so here we see there were no lifetime gifts, but there are a few creditors. You know, mom had some credit cards. So we'll come back to that in just a second, very briefly. So what are the things that we see here? The CCRC, and we also see the deposit and the death claims on the IRAs. We've got to make sure of that. Look at the issue here. We've got a child who's now disabled 20 years later. They have a traumatic brain injury, but look that when Janet, the survivor, died, she left everything outright, okay? Well, I'm sorry, she left everything in further trust, forgive me. And she left trusts for these kids, but This child is now disabled and she never changed her estate plan. So down at the bottom, we are fortunate now to have a Maryland decanting statute. So decanting would allow the trustee here to take this trust that was established for this now brain injured child. And that trust was not a special needs trust. It is not the appropriate trust for this brain injured child, but this trust needs to be changed. So the trustee could decant that trust into a special needs trust. So we have the death claim that has to be made on the life insurance. We have the death claims that need to be made on IRAs. We can decant that child's trust to the appropriate trust, and we have to deal with the CCRC deposit. But here, except if that CCRC deposit was in the name of the person and not coming back to the trust, that would be the only case here where we have probate. Going to the next fact pattern, I'm just going to hit the timer again very quickly. We're going to take 1 minute to look at this kind of disastrous scenario. I want you to look at this. Here's a person who passed away with no will, and just see briefly, and then we're going to move on. What are the issues here? We'll take about another 30 seconds on this. Okay, in the interest of time, I'm going to stop the timer. So here we have a man who he's really married, but very much separated, and he passed away without a will, and he has a child who is in bankruptcy, unfortunately. So is he going to have probate? Well, the answer is yes. So he's going to have probate even though he has no will, he has no estate plan. He's going to have the laws of intestacy take over. This is an intestate estate. So his checking and savings is going to go through probate because it had no joint owner in our fact pattern. The beneficiaries are going to have to make a claim on the IRA. So let's just assume he did a good job and he did name beneficiaries on his IRA. So they will have to make death claims, whoever those beneficiaries are. The automobile will go through probate because it was in his own name. The life insurance, unfortunately, will go through probate because it had no beneficiary. Remember, life insurance will not go through probate most of the time because it has a beneficiary that someone is going to make sure is designated. Here we have savings bonds again. Those are going to go through probate. And what do we know about this? They are going to have taxation. This is called income in respect to a decedent, IRD. And he made lifetime gifts of $500,000. So he used some of his exemption amount, but remember he had a $13,990,000 exemption. And when he made these lifetime gifts, let's assume it was cash, it really is not going to matter because he does not have enough of an estate to worry about the estate tax. And he gave away those assets for federal purposes. He did use some of his exemption, but he is not going to have any gift tax. He does not have any estate tax. And the one thing that I have not mentioned throughout these examples is that there is a new spousal elective share law in Maryland. And we're not going to cover that too much, but just remember that spouses that don't receive a certain amount, it's a formulaic amount, spouses are protected now in Maryland, like in ways that they would never have been protected before. So we have to be aware if we're not leaving 100% to the surviving spouse, we have to look closely at what the surviving spouse elective share is that they could elect. But back to this fact pattern, what are the issues again? We have to make claims on the IRA, but what is the big issue here? The big issue is that this estate is going to be distributed according to the laws of Maryland because the person had no will. And you know, we have this estranged spouse issue. So there's a lot of things going on here, and this is the kind of situation that you could encounter as a fiduciary.
Hey there, Steve.
All right. Jeff, go right ahead.
Can we pause for just a couple questions?
Yes, then we'll get into the latter portion.
First question from our good advisor friend, Eric. What's the difference between having a transfer deed on death for a home versus placing the home in a trust?
Thank you very much for that. So if I understand, Eric, what you're asking, if we place a house in a trust, it's basically we want to avoid probate on the house. We're going to retitle the house in the name of the trust. In the old days, prior to, I would say, 2010, this was something that most married people didn't understand, that if they put their house in a trust, and they were husband and wife, let's say they owned it as tenants by the entirities, where they have a basic level of asset protection. A lot of people would give up their tenants by the entireties protection because they were told, and they were told that avoiding probate was very important, so they would do that. And when they put it into a trust, they would give up their husband and wife protection. Well, there are new laws that are about 12 years old now, I guess, that say that if you put husband and wife or spousal property into a trust as tenants by the entireties, that it will retain its tenants by the entireties status. So the point there is people that put assets in trust, it's like a house, it's going to avoid probate. Someone could say, well, I don't want to use a trust. I just want to create a deed that says that it avoids probate just because I said it does. So I get to live in the house, let's say a life estate deed. I get to live there forever, but at my death, it passes kind of like a TOD, transfer on death. It passes to my children, or who I would call the remainder men. So that technique is simple, and it comes in two forms. One is it's a life estate with power. The person can do that, anticipate avoiding probate. And by the way, Eric, the person gets a step up in basis at the time of death. So it's a very powerful technique. But they can change it at any time. If they say, I'm moving away from this cold weather down to Florida, they just undo it and they buy a new house in Florida. The second version of this is a life estate deed with no power of sale. This is a whole different can of ball of wax. This is a Medicaid planning technique. The person reserves a life estate, but at their death, it passes to their loved ones. But because they gave up the power to sell, they give away their house basically to their children at the time of the transfer. So there's a life estate deed with power, life estate deed without power. At the death of the person, it passes with no probate. It gives a step up in basis. If a person uses a life estate without power, they are starting the Medicaid 5-year look period, and that is a tool. But we have to be very careful with that one because that one's irrevocable, and it might be better in some cases to use a trust. But those are the fundamental differences.
Okay, the last question for now is, my assets are titled under a revocable trust and tax identification is under my social security number. Upon my death, how does the trust come into existence and a tax identification number get created? First attempt to get one was truncated.
I gotcha. Well, thank you for that excellent question. So your question epitomizes the big confusion that people have, which is, I had a living trust, I had a revocable trust, and it was identified by my social security number. Uncle Sam ignores the trust, right? It's just your social security number, it's just you. And then upon your death, if we say this flat line is your death, that trust becomes irrevocable and it has to be administered. And that's where it gets the tax ID number that identifies it for Uncle Sam, because Uncle Sam wants to know who's going to pay the tax from the time of death until the time of distribution, which will be reported on Form 1041 for the interest and dividends from that time. So having trouble getting that, it could be that maybe you tried to get it on the IRS system and the system was down. I don't know what the trouble was, but that's the difference. It's going to have a tax ID number, and then when you distribute the trust, fully distributed, if it's going into further trust, those trusts will have further tax ID numbers. But if it's going outright distribution, then you're done at that point. But you have to use that 1041 to report tax under that EIN. So if you continue to have trouble getting the EIN, let me know. But that is the prime example of this presentation of a living trust becoming an irrevocable trust that has to be administered. And we would call that an administrative trust.
Steve, thank you.
Thank you, Jeff. All right, now in the interest of time, because I did linger a bit in those examples, we want to encourage clients, advisors, everyone involved, trustees, to have empathy for the person who has just suffered a loss, as many of you may have on this call. Really think about what kind of support is happening. Does the surviving spouse have assets that they can tap? I've recently just been experiencing a situation like this over the past 3 weeks. If you are a professional, your whole firm should be involved to support this person. I have lost a loved one in the past year, and I can tell you it was invaluable to me, the support of other people and their sympathy. So just don't ever underestimate the power of that. Be creative. Be creative about resources. Have the ability to refer, and I know many of you do. Maybe even individual clients or prospective clients have this, and be a counselor, be a shoulder for this person. Now, we want to assure the fiduciary that they have to take care of themselves first, especially if it is a surviving child, surviving spouse. There is most of the time no hurry, most of the time. Sometimes there is a hurry, pipes have frozen, or there's rental property, or there's a bunch of LLCs, but most of the time in a prototypical situation, there's no extreme hurry, no need to pressure a surviving spouse, let's say, to have to address things quickly, but some surviving spouses do. Survivors should be encouraged that their advisors are going to be coordinating. Advisors, we should coordinate. Assure clients, give them confidence, make sure funds are available pre-death. We want to make sure we thought about that. We want to talk about final arrangements before it's too late and now there's confusion. Family related issues. What if there are siblings that don't get along? There are estranged people. We want to talk about that. And again, I'm being redundant intentionally here. We want to send sympathy, bouquet of flowers, thank you notes, and I'll tell you, again, I cannot tell you how powerful this is. When you do it and it's done from the heart, it makes a big difference. Let's talk about the legal step-by-step process. You always have these checklists now. Let's talk about probate versus non-probate. What do I mean by that? Wills versus revocable trust. Similar steps, similar checklists, but it's a little bit different. Organization is the key. You'll see that when someone chooses to avoid probate, the trust still has to be administered. A good trustee is still going to administer. Let's start with the wills, though, the probate process. As you'll see on the checklist, letters of administration have to be issued. Death certificates, let's not get ahead of ourselves there. Death certificates have to be issued. Sometimes that's timely, sometimes it isn't. In a typical regular estate, there has to be an inventory, an information report, as you see on your checklist. Date of death values need to be obtained. Yes, there is some wiggle room here, but we really want to get the date of death values, and the Register of Wills wants to know that. And remember, on the information report, this is where Maryland will attempt and does collect inheritance tax. Remember, the Register of Wills collects inheritance tax, and that information report, which the personal representative has a fiduciary duty to complete, that information report is going to alert the Register of Wills about whether there's 10% inheritance tax due. Remember, Maryland has abolished inheritance tax except to non-lineal descendants, but we still have an inheritance tax. Valuations have to be made. There can be an alternative valuation date in some cases. Creditors have the right to make a claim against the estate. We talked about the spousal elective share. Disclaimers for tax purposes have to be made for Maryland estate tax purposes and I should say for federal estate tax purposes within 9 months. With the portability amounts, disclaimers are not so common anymore, but they're still very powerful when they need to be used. And the federal and state estate tax returns need to be completed, especially if a surviving spouse is choosing the portability election. Q-tip election needs to be made. And to make a long story short, a Q-tip is election for a marital share. It is an election for what we call a marital trust to choose to tax the assets and the estate of the surviving spouse. So the Q-tip election has to be made on Form 706. We talked about the portability election. The administration account has to be due within 9 months if it's a regular estate. Again, I'm going to skip down the line here for just a little bit in the interest of time. Retirement plan accounts have to be claimed within a certain period of time. And we have to be aware, again, of the Secure Act and what it means as far as the time period that Uncle Sam, for most people, is accelerating the income tax on inherited IRAs. Now, the income tax returns have to be filed. We talked about the 1041 for that nice gentleman or lady who had asked the question just a few minutes ago. And of course, the decedent's final income tax returns have to be filed. Closing letters have to be obtained from IRS and the Comptroller of Maryland, and so forth. Now, let's switch over to a trust administration. What is this non-probate administration all about? And as the nice person teed up for us so beautifully, the revocable trust became irrevocable and now it has to be administered. So many of these things are similar, but let's think about this for a minute. At the time of death, when someone has a fully funded revocable trust, here's the time of death. Are the assets immediately distributable? And the answer is yes. That's the power of a revocable trust. And let's pretend that a person had an only child and that child was healthy. Well, you can't think of a more powerful technique. Here we have a revocable trust. It's immediately distributed to a single individual. Wow, you can't get any better than that as far as minimizing confusion and process. But if there's 1, 2, 3, or however many survivors, the surviving fiduciary has a fiduciary responsibility and they need to go down this checklist. Beneficiaries have to be notified. Beneficiaries are entitled to information. This is huge because if they are not notified, and sometimes it seems counterintuitive, of course they know the person died. But if they are not notified timely under Maryland law, the fiduciary can be removed. So this is the big issue, whether it's probate or non-probate. We don't want the heartache and embarrassment of being removed as a fiduciary because you did not fulfill your fiduciary duty. Creditors can be notified even with a revocable trust. This is a best practice. In 2014, Maryland said creditors can be notified. Actually, creditors can make a claim against a trust, basically, even though I've never seen that happen. A best practice, even though it seems like a waste of money, is to notify creditors so that you can foreclose the claims of creditors against a trust. You'll notice many of these things are very similar. This little bullet point there, the spousal election, this is changed, so you need to mark that on your sheet. Jeff, we need to update that slide. There is a new spousal elective share in Maryland, and this is something you need to be aware of. Surviving spouses are entitled to a minimum amount, and if they don't get that amount, they are entitled to it for the protection of spouses. And it also has an implication for elder care planning, which is another subject. Here you'll see the Q-tip election has to be made on time, the portability election. Many of these things are very similar. What would I take away from this if I were you? I would take away that even with a revocable trust, there is administration, and a good fiduciary is going to understand that even though the trust avoids probate, even though the trust was designed to be efficient and to save money, there's still a series of steps they should consider to make sure they fulfill their fiduciary duty and protect themselves. If there is more than one beneficiary, protect themselves, and when they get ready to distribute the assets, to get a release, to get a consent form. This is the next bullet point here that we're looking at. They are entitled, the fiduciary is entitled to get released, to say, I've done my duty, I've done my job, I am not going to distribute these assets until I receive a release and a waiver and a refunding agreement. What if IRS comes back and says this estate still owes taxes? I have the right to ask you to give the money back to pay the taxes that are owed. You'll see that the 1041 issues are similar, and the closing letters. That's what I really want you to take away, is that the use of checklists and that the process is similar no matter whether we have a state administration or trust administration. Of course, the trust administration portion of it is private. The estate administration portion of it is public. Now, again, let's get back to these practical steps. Scheduling a meeting with the surviving spouse, but not in 5 days, not in 2 days. I saw a situation recently where a client of ours had passed away. and the persons involved in the business affairs of the surviving spouse were knocking at her door within a day or two. And I just thought that was the most inappropriate thing I had seen in quite some time. We don't want that to happen. We want to protect the survivor, coordinate with advisors, use the checklist. Organization, again, is the key. We want to have an inclusive process. Now, let me talk about that a little bit. If you're a fiduciary, the folks who survive, the people that are either qualified beneficiaries under a trust, or they are interested persons or beneficiaries under a probate estate, you're going to have to make a decision whether you're going to have kind of an inclusive, you're willing to share information process. Now remember, they are entitled to information, especially in a trust. The surviving qualified beneficiary is entitled to information and notice. And in my opinion, they're entitled to all information. So in most cases, in my experience, subject to the circumstances you might be dealing with, you're probably going to want to have an inclusive process. And by doing that, you may minimize problems. Every situation is different. Some beneficiaries are very demanding, but I would encourage an inclusive process subject to the facts and circumstances. Again, we want to make sure survivors or surviving spouses are coping. Again, everything should be methodical and unhurried unless there is a reason to hurry. Surviving spouses are going to naturally want to get their own estate planning in order. This is a very painful thing to do. We want to be sure we're sensitive to the timing of that. We're going to talk about traditional document storage and so forth. Remember, many clients are using, if you're an advisor on this webinar, they're using your vault, or they're using our cloud here at Elville and Associates. And we just want to make sure in the readiness process that we understand where documents are stored. Digital assets, are they on a archive? Are they, do they have to have passwords to get into them? We want to make sure that certain assets, we have a new world now of digital assets. We want to make sure that we can access those. But basic foundational question is, where are the documents stored and can they be accessed? Are there stock certificates? On and on and on. Now, what are the most significant tax and problematic issues that we see? And I know that I'm going a little bit long today, so bear with me. We want to review the titling of assets, obviously, prior to death. Remember that all estate planning is goal-driven, G-O-A-L. We want to value assets after death, and in some cases, value assets before death. But clearly, we want to value assets after death. And there's a lot of momentum for some reason to not value things properly, but this can have ramifications not only with fiduciary duty, but it can also have ramifications about minimizing taxes to make sure that we're getting the proper step up in basis and so forth. Be careful about retitling accounts. Be careful about accepting life insurance proceeds too soon. So many of the participants in the advisory team, or if you're a client or potential client, your financial advisors or other advisors have a tendency, and it's all in good faith, to help wrap up things very quickly. And we don't want to do that. We want to be methodical. We want to look at the documents and see what they require. Do the documents require a trust that is created for a surviving spouse or others before the money is retitled into the personal name of the beneficiary? We want to make sure that surviving spouses or others don't cash life insurance checks until we are clear that they are going to accept those assets in their surviving estate. And this is usually a surviving spouse. We want to make sure there's no inheritance tax. If there's inheritance tax due, especially if someone has inherited an IRA, remember the Register of Wills is going to want to assess that inheritance tax pretty much as soon as the person has claimed the IRA. Some people get caught up where the beneficiary has accepted an IRA, inheritance tax is due, but they did not notify the Register of Wills about that. Remember that with someone who receives an IRA, that is a non-probate asset. And let's go back to trusts. If someone receives a residuary distribution or a specific distribution from a trust, that is a non-probate asset. So there is a special form that has to be filled out by the fiduciary, by the trustee, and it's called Application to fix inheritance tax on non-probate assets. Yes, I'll say that again. Application to fix inheritance tax on non-probate assets. So even though it's not a probate estate, they still, as a fiduciary, have to report that this person, like a niece or nephew, received an IRA or received a distribution from a trust. So that is a fiduciary responsibility, and that's a big thing to remember. Portability election, we talked about that. That's something we don't want to gloss over. Not everybody is going to make the portability election, but generally it's a good idea for the surviving spouse to do it. They do not have to do it. The Q-tip election would be necessary if the documents create a marital trust, so we want to do that. Failure to run notice to creditors. What if there was an outstanding creditor, but the fiduciary in a trust did not notify creditors? Remember, in a probate estate, the Register of Wills is going to notify creditors as part of the probate process, but in a trust, it's optional. So I think as a best practice, even though sometimes the decedent had no debts, there's no reason to believe they have creditors, it may still be a good idea to run the notice to creditors for bare minimum purposes of foreclosing potential creditors. How can financial advisors, CPAs, attorneys, personal representatives, trustees all work together to support clients? And if you're none of those on this call, you're a client or a potential client, what I want you to think about is communicate. We want to communicate, especially if you're a member of the advisory team, as we would call it. Coordinate with the client, give the client assurance, and let's decide, if we are advisors, let's decide who's running this team or one or two people so that there's not confusion, okay? We want to invest significant time during lifetime, obviously. That's the mission of all the advisors, I'm sure, on this webinar. If there's an obvious illness, we should really expedite things. My experience has been, unfortunately, that where we see someone is really struggling, that death could happen sooner or later, or disability, by the way. And we want to encourage people to use a memorandum of intent, or maybe I should say a letter of wishes. So one of the most, I think, neat things, or cool things, I would say, from the 1970s that I could pass on to you is, if your client is a thoughtful person, they could use a letter of wishes. This is a letter of wishes to pass along their goals, values, their intentions, but also to instruct their trustee in the future about what is important to them. When they leave a trust for beneficiaries that is going to distribute according to health, education, maintenance, and support, an ascertainable standard, what in the world does that mean? Most people don't know what that means. Most trustees will try to figure that out, but a letter of wishes would help a trustee to have a foundation. Even though it's an informal thing, it would give them a foundation to be able to decide, how do I approach the administration of this trust to know that I'm carrying out my fiduciary duty in accordance with what the grantor wanted. We want to encourage everyone to utilize organizational tools. We want to encourage education of family members who may serve as fiduciaries. We want to facilitate a method of reporting to all advisors. And again, this is not easy to do. So that's why in our webinar about how to perfect your estate planning, we always encourage that the client should sit with all of their advisors together at least once during their lives, and maybe on a systematic basis, even though it's a very high bar to get there for the advisor and for the client. Ideally, this is what would happen. We want to disseminate information quickly after a death event. And again, a lot of times the death certificate is what holds up the process. But we want to instill confidence in the fiduciary or in the client that the advisory team is working together. So Jeff, I've gone over by about 5 minutes. I really did intend to end at 11 o'clock. We want to be a resource to you. If you are a client or a potential client, please set a consultation with us. We're here to provide resources. We're here to help you understand what your goals are. We're here to help unravel mysteries. If you haven't done your estate plan, we want to help you do that. If you have an older estate plan, we generally review those at no charge. Please bring your documents. Please bring your questions. Now, if you are a person who is worried or you want some guidance about how to administer an estate or trust, we're here to help as well. Many people will do planning based on the idea that they want to be assured. The number one thing they want to be assured of in many cases is, if I pass away, there will be resources available to you, to my family, excuse me. And that is what we want to instill, that we are a resource. The advisors on this webinar are resources. The whole world of advisors is here to assist you. If you don't have an advisory team, we want to help you formulate one. And again, we want to give you the time to think in this busy, crazy world that is a 24-hour news cycle. It's tough to watch the news these days for some people. Lots of people have concerns. If you have those concerns, please let us know. We will want to sit and listen and provide counseling to give you time to think. And we'll help you figure out what your goals are or what the holes are in your planning if you're concerned about that. Last thing I'll say, Jeff, is trustee selection is one of the biggest things that people are concerned about. So if you want to have a discussion about trustee or fiduciary selection, please talk to us. And I'm happy to say that there's lots of flexibility in Maryland law today compared to what it was 20 years ago. So with that said, I know you're very busy on this Wednesday. I'm going to thank everyone, including Jeff, for all you do, Jeff, and being the moderator here today. And I thank everyone, and I'm going to stand down. Have a great day. Turning it over to you, Jeff.
Well, thanks, Steve. This is always such an important presentation. It's some way, shape, or form, everybody on this presentation will probably be involved in an estate or trust administration matter down the road or in the close future here. So let's pause for a couple of questions here, and then we'll end on time at no later than 11:15. Let's see here. Here we go. Okay, first question, Steve. If your primary residence is in a trust and you get a homestead exemption, is that exemption transferred with the trust when the trustee dies?
Thank you for that. I'm going to say that's an esoteric question. My gut reaction is to say no. See, that homestead exemption is, if I'm understanding your question right, is really personal to you. And remember, Maryland's homestead exemption is really not much compared to a place like Florida. So when we pass away and we had a homestead exemption, it does not pass, in my opinion, to the surviving heirs, because one, we don't know if it's going to be their primary residence. And if that house continued to be in a further trust, it would depend on who lived there and so forth. So I would say generally the answer is no, but that's a very good question.
Okay. Regarding gifting, can you please explain if there is a Maryland look-back period regarding estate tax?
Well, thank you very much. There is a situation in Maryland where with regard to death tax, let me start with inheritance tax first. So with an inheritance tax situation, if you make a gift to someone who's subject to inheritance tax, like a nephew, let's say, well, if you make that gift 2 years prior to your death, that person is going to be subject to inheritance tax if you died before that 2 years. But if you died beyond the 2 years, the person will not be subject to inheritance tax. So that's just something to think about with death tax relating to inheritance tax. In my opinion, and I'd have to look at the code, Maryland has no gift tax. So when a person is facing a situation where they might be passing away and they were to make a gift for Maryland estate tax purposes, in my opinion, subject to further look at that particular situation you're talking about, I believe the person would be able to make a gift and it would be removed from their Maryland taxable estate because Maryland has no gift tax. It would be removed immediately from their estate. So that is my opinion on that. And that technique can be used where there's a deathbed situation. Of course, any kind of gift has to take in consideration the whole. What is being gifted? Is what is being gifted cash? Is what is being gifted appreciated securities, which are going to pass subject to a loss of a step up in basis and actually cause a capital gain if they are sold in the future. You know, all of those things have to be taken into consideration, including the federal estate tax exemption and gift tax exemption and how much this would use of that. But for Maryland, there is no gift tax and would pass, in my opinion, out of the estate to reduce the Maryland taxable estate.
Okay. So last two questions from the same person. If a surviving spouse chooses portability, when they pass, they are under the dissue exemptions. Are the MET-1 and 706 still filed in order to prove the estate is under the exemption amounts? And also, can you serve as a fiduciary? Can you serve as a fiduciary or trustee if needed?
Oh, thank you for that. Yes, I would be, yeah, we do serve in those fiduciary roles and we'd be proud to serve. So thank you for that. The portability election having been filed, I would have to think about this for just a second. I would say it depends on the size of the estate, because remember, when the portability election was made, it basically was made for purposes of electing portability only. So my initial reaction is to say no, that an estate tax return would not have to be filed if it did not meet the threshold amount at the death of the survivor. Because at the first death, the portability election was already made at that first death. So my initial reaction is to say no if it's very clear that at the death of the survivor, the estate was not taxable.
Okay, one more. We'll jump into one more here. If your son is an accountant and lives in Virginia, not Maryland, is it okay to designate him as our personal representative?
Thank you very much for that nice question. The answer is absolutely yes. I got a chuckle out of that because my son is an accountant, and so I got a little chuckle out of that. But the answer is yes. That person can be, your son can be your personal representative if you had a will, and certainly could be a trustee. If there is an out-of-state personal representative like your son, he can serve, but there will have to be what is called a resident agent, someone in Maryland that can receive service of process. And it probably is never going to happen that their service would ever be needed, but the answer is yes, so long as there's a resident agent in Maryland. So I think that's a great question.
All right, Steve, great presentation to our attendees. Yeah. Thanks for being here. Great questions as well. I always send out the video slides, in this case, the checklist. I'll send out the letter of wishes that Steve alluded to, and some links to our recent webinars about trustee selection and the other ones that Steve alluded to. We have a great upcoming schedule here for our webinar series, including an in-person presentation down at Rockville Senior Center with our principal attorney in Rockville, Lily Hummel. So looking forward to hopefully seeing you in person, and also here again on the Elville webinar series. Hope you have a great day, everybody.